is my design infringing on somebody else's design patent? Or is somebody else's design infringing on my design patent? This video is going to talk about the tests for determining design patent infringement in the United States and a few other things as well. My name is Derek Fahey. I'm a registered patent attorney and a trademark attorney with the Plus IP firm. We frequently acquire design patents and enforce design patents for clients. And I wanted to talk about the seminal case for design patent infringement, which is the Egyptian goddess case. The test is actually known as the Egyptian goddess test. Let me go share my screen here. And the Egyptian goddess test or Egyptian goddess case is Egyptian goddess versus Suiza Inc. And in that particular case, there was a design patent, which is USD 467389. I'm missing a letter here. Sorry about that. But the design patent, this was the patent issue. It's a nail buffer. It's a square. It's a tubular shaped body. It actually has openings on this side, and then on three sides, 1, 2, 3, it actually has a buffing mechanism or like a buff plate. And the patented issue or the accused device is here. And that's a buffer that has a square. It's a square shape. It has a tubular shaped body. It has open ends. And it actually has the buffing part on all four sides. And the question that was put forth at the district court was whether or not, on summary judgment, this device, based upon if all the facts were considered to be true, whether or not this design infringed on this patent. And district court found that there was no infringement, and the Federal Court of Appeals issued an opinion about whether or not this device infringed on this device. And essentially, the Federal Circuit Court of Appeals affirmed the decision of the lower court. And we're going to talk about that decision. Essentially, the test for determining design patent infringement is whether an ordinary observer that's familiar with the prior art would be deceived into thinking that the accused design was the same as the patented design. Now, a couple things I want to talk about here. It says the ordinary observer that's familiar with the prior art. What does that mean? Well, prior art means everything that's existing before a patent application was filed. So that means other patent applications. It means things on Amazon. It means things on the internet, things being sold. You don't have to know it, but the ordinary observer is familiar with everything that's existing before the patent application is filed. Now, when we look at, this is actually the patent at issue. This is the USD 467389, and you'll see here that on this particular patent document, you'll see all these references here, references cited. This is actually all the prior art, all the references that the examiner actually considered during the prosecution. And I actually highlighted this one here, which is the D416648. And we're going to talk about that briefly in the next couple slides. But so that's important to note, that how when you have a design patent, all the documents, all the references are going to be considered that are going to be on here. And the test, as I mentioned before, for design patent infringement is whether an ordinary observer that's familiar with the prior art, so they have to know this, would have been deceived into thinking that the accused device was the same as a patented design. All right, so let's move forward. All right, so let's go to let's go through the analysis here. So in this particular case, the court of the Federal Circuit found that when you look at the prior, this was the prior art, and this was actually a nail buffer. This was actually that USC 416648 patent that I referenced in the previous slide, right, which we have here. Again, see that 468? That's actually some of the prior art. And you'll see here in this particular reference, this actually has a nail buffer. It's a triangular shape, and it's tubular, so it's tube shaped. It has an open side. It has a buffer on all three sides. This also is a buffer that's square, that has closed ends, and it's called the Faley buffer. And it actually has it actually has, this particular, it's got buffing sides as well. All right. So the question posed to the court was whether or not, go back here, whether or not this particular device was infringing on this particular design patent. When you're considering design patent, the first part is the court has to actually construe the claim, has to construe what actually is the claim for the design patent. And in this particular case, the court construed that it was a nail buffer with an open end, hollow body, and raised rectangular pads and open corners. So you have raised rectangular pads right here, and right here. You have an open body, hollow, and open corners. And the court found that, first off, you have to consider all non-functional features. So if it's functional, you cannot consider those elements. Any functional aspects of your design, you cannot be considered for design patent infringement. You have to consider only the non-functional elements. And the court, in this particular case, the Egyptian goddess case, the court actually confirmed the lower court decision and found that because of the prior art here, okay, they found that they looked at the Nailco buffer. This is actually the Nailco buffer was actually cited by that was a buffer that's referenced in this patent. And they found that in the context of the nail buffers, that it's not substantially the same. So the court found that because when you consider the prior art, when you consider you're an ordinary observer and you're looking at this in light of the prior art or in the context with the prior art, you would not be deceived because this actually has a fourth pad. This has a fourth pad. This only has 3 pads. The court found that you would not be deceived because there's other references that were prior art. When you consider if you would be deceived if this was the same as this, because the other prior art was out there, you would not be deceived into thinking that they were the same thing. So what does that mean for you? If you have an exact copy that is shown or claimed in a design patent, certainly it's going to be, I think it's going to be easy to say that it's infringing, or someone is going to be infringing on your particular patent or design patent because it's exactly the same. Where it gets challenging is if there's some differences. So when you're looking at if there's any difference between the claim design, which is here, and and the accused device, you need to take a look at what was existing before, right? So if there's a lot of prior art that's existed before, here there's a lot of prior art related to pads that existed before the patent was granted, before the application was filed. It's going to narrow the scope of protection. So something to think about before you assert your patent against somebody else. If it's an exact copy, that's great. That's certainly going to be considered design patent infringement. If there are differences, that's okay. But if there are a lot of differences and there's a lot of prior art that's very close to your design, it's going to be somewhat difficult to assert a claim for design patent infringement. If you are selling products in e-commerce, design patents can be a great way to get certain e-commerce platforms to take down other competitors' products if it's an exact copy. Also, you can litigate the issue in federal court. That's certainly an option as well. And also, if you have an issue with other products, you can also consider potentially, there's one option is also if there's any copyright protection on the design. If it's the look and feel of the product, certain products can be protected with copyright. You can't have a functional element protected, but a look and feel of the product can be protected in certain cases with copyright protection. That's something you can think about as well. So with that, hope you enjoyed this call or this, video. But remember, the test for determining design patent infringement is whether or not an ordinary observer that's familiar with the prior art would be deceived to thinking the accused device is actually the same as a patented device. So hope you enjoyed it. You can find me online, Derek Fahey, PA. And if you have any questions, just send me an email at derek@plusfirm.com. Thanks so much for watching.